and the fundamental rights of citizens in a higher law that cannot be unilaterally changed by an ordinary legislative act, cannot be unilaterally amended easily or changed according to the whims and fancies of people in the legislature. This higher law is referred to as the Constitution. The content and nature of a particular constitution, as well as how it relates to the rest of the legal and political order, varies considerably between countries, and there is no universal and uncontested definition of a constitution. However, any broadly accepted working definition of a constitution would likely describe it as a set of fundamental legal political rules that are binding on everyone in the state, including ordinary lawmaking institutions. That is, it's binding on the lawmaking institutions, for example, the legislature or the parliament. And the fundamental legal political rules that concern the structure and operation of the institutions of government, political principles, and the rights of citizens. And these rules are based on widespread public legitimacy. It is widely accepted by the public at large in that particular country or a territory. And these fundamental legal political rules are harder to change than ordinary rules. It is more difficult to amend the constitution as compared to other laws. For example, a 2/3 majority vote or a referendum is usually needed to bring change to a constitution. And these fundamental legal political rules as a minimum meet the internationally recognized criteria for a democratic system in terms of representation and human rights. If the country is party to an international convention, and if it has ratified particular international conventions, let's say the International Convention for the Protection of Civil and Political Rights or the United Nations Declaration of Human Rights, then it must in a way adhere to it and does not violate any of the fundamental principles therein. The fundamentals of a constitution, the functions essentially of a constitution. The constitutions can declare and define the boundaries of the political community. It defines the jurisdiction of that particular territory or country in questions. These boundaries can be territorial, the geographic borders of a state, as well as its claims to any other territory or extraterritorial rights. It can be within the main territory itself or any other territory, maybe far away from the main territories on which they have a jurisdiction over. For example, a colony or a protectorate state that is under their jurisdiction. And personal jurisdiction or boundaries in terms of citizenship. Who is and who is not a citizen of the country? How do you gain citizenship? How do you lose citizenship? All those aspects are provided in the Constitution. And therefore, a Constitution often distinguishes between those inside and outside the polity. There are two types of entities, especially when it comes to territories and borders and citizenship. They're either citizens of a country or there are aliens. Aliens in this sense does not refer to extraterritorial beings. It refers to people from other countries, foreign individuals. So if you are a Maldivian and you go to the UK, in the UK you are an alien. In the same sense, if a person from the UK comes to Maldives, in Maldives they are an alien. Constitutions, the second function is that constitutions can declare and define the nature and authority of a political community. They often declare the state's fundamental principles and assumptions, as well as where its sovereignty lies. For example, it defines who is the head of the state and who is on whose who on whose head the responsibility of being the sovereign lies. For example, the French Constitution declares that France is an indivisible, secular, democratic, and social republic, and that national sovereignty belongs to the people, who exercise it through their representatives and by means of referendums. So the sovereignty is in France, in the French Constitution. Sovereignty is lies with the people, but they exercise it through their representatives. That is through the people that they elect to represent them. The Constitution of Ghana states that the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised. Yeah, even in Maldives, can anyone tell me who is the sovereign head in Maldives?
Maldives, we have parliamentary sovereignty.
Yeah, even then it's parliamentary democracy, right? So the people in the parliament are essentially the representatives of the public. So
sorry, constitutional democracy, right?
Yeah.
Yeah, we have constitutional. UK have parliamentary sovereignty.
Yeah. Like even then, even regardless of that, there is still constitutional supremacy. Anyway, third function is that constitutions can express the identity and values of a national community. As nation building instruments, constitutions may define the national flag, anthem, and other symbols, and may make proclamations about values, history, and identity of the nation. Within the constitution, it is stipulated what the flag of a country would be, what the symbol or emblem of country would be, and what values that people of the country shall have. This is mostly embedded in the preamble of the Constitution. The preamble of the Constitution is essentially an introduction to the Constitution, but it is an undertaking taken by every citizen of a country to follow the Constitution and to have and respect the values that are provided in the Constitution. Constitutions can declare and define the rights and duties of citizens. Most constitutions include a declaration of fundamental rights applicable to citizens. At a minimum, these will include the basic civil rights applicable, basic civil liberties that are necessary for an open democratic society, such as freedom of thought, freedom of speech and expression, freedom of press, freedom of due process of law, right to due process of law, and freedom from arbitrary arrest or unlawful punishment, or freedom from double jeopardy. Many constitutions go beyond this minimum to include social, economic, and cultural or specific collective rights of minority communities, rights that are specifically designed to ensure that marginalized communities and minorities are protected. Yes.
So, Miss, under the Modi's constitution, who will have the highest power in Modi's?
Highest power as in the sovereign?
Yes.
The sovereign head in Maldives is the president.
Yes, but the Modi's constitution says the power is from the people and it's ends with the people. So
Yeah,
still,
the
will it be the
that in
president?
the constitutional sense, it is the people. However, through the representatives of the people are elected and to the parliament, and the majority of the parliament, um, the ruling party forms the government, right? And the leader who's chosen from the leading party ends up becoming the president.
So, would you say that the president is the last say in all the matters, or will the people give the last say even through his presidential term?
Uh, in case of matters that need people to be referred to, then a referendum can be brought. But the institutional head, the sovereign head of the government, is the president, in the sense that the president's assent is required, or the president's ratification is required to pass a law, right?
Yeah. Yeah, so this is there's two kind of question arise because the case of Hadif Filladu, where the president declared that it is a separate area in Filladu. This case is something like that, I think, because the people decided that whether even the president could not actually go forward with his own declaration because people did not want it. So I have this question whether it's the people or the president who have the higher power in the sovereignty or in any matter actually in the country. So if the people does not want or if the people want, even through his term, it seems anything is possible if the people want it. Enough people want it in a specific area or even in the country. Is that right?
Yeah. Anyway, we'll discuss that later in the class after we're done with this lesson, because I really need to rush through this. We'll discuss that later. Yeah, some rights are provided to protect the interests of minority and marginalized communities, and some rights may apply to both citizens and non-citizens, such as the right to be free from torture or physical abuse, or right to life and right to privacy. Constitutions can establish and regulate the political institutions of the community, and constitutions define the various institutions of government. They prescribe their composition, powers, and functions. It regulates relations between the institutions of government. And almost all constitutions establish legislative, executive, and judicial branches of government, separation of powers. And in addition, there may be a symbolic head of state institutions to ensure the integrity of the political process, and institutions to ensure the accountability and transparency of those in power. For example, an ombudsman or an ombudsperson. The institutional provisions typically provide mechanisms for the democratic allocation and peaceful transfer of power, such as elections, and for the restraint and removal of those who abuse power or who have lost the confidence of the people. Example, impeachment procedures, or even referendum to remove. That is a majority. Constitutions can divide or share powers between different layers of government or sub-state communities. Many constitutions established federal, quasi-federal, or decentralized processes for sharing of power between provinces, regions, or other communities. Federalism is a system of government in which the same territory is controlled by two levels of government. For example, a state government and central or union or central national government. These may be geographically defined, as in most federations such as Argentina, Canada, or India, or they may be defined by cultural or linguistic communities. Example, the 1994 Constitution of Belgium, which establishes autonomous linguistic communities in addition to geographical regions. The linguistic communities in Belgium refers to the German-speaking areas, the French-speaking areas, and the Dutch-speaking areas. It can also refer to such quasi-federalism can refer to the decentralization of power and governance in local government in certain districts and in the nation as a whole. Constitutions can declare the official religious identity of the state and demarcate relationships between sacred and secular authorities. This is particularly important in societies where religious and national identities are interrelated, or where religious law has traditionally determined matters of personal status or the arbitration of disputes between citizens. Here we can take the example of the Moldovan constitution, which says that the religion to be followed in the country shall be Islam, and that the laws of Maldives shall be according to the tenets or the principles of Islam, and it shall follow the Sharia system. So this is an example of Islamic constitutionalism, where principles of Islam are followed along with the traditional basic concepts of constitutionalism. This is opposed to, let's say, a secular constitution like that of the UK, India, or the United States, where it doesn't specify a specific religion that is to be followed, or the specific principles of a particular religion that is to be imbibed or infused in the constitution. Constitutions can commit states to particular social, economic, or developmental goals. They may take the form of judicially enforceable socio-economic rights, directive principles that are politically binding on the government, or other expressions of commitment or intent. These socio-economic rights refer to labor rights, that the state shall take steps to ensure that the minimum wage is provided, that employees and workers live in proper living conditions, that they have a proper standard of living, and so on. The Constitution is at the intersection of legal, social, and political life. The constitutions as legal instruments. Constitution marries power with justice. It makes the operation of power procedurally predictable, and it upholds the rule of law and places limits on the arbitrariness of power. It is the supreme law of the land, and it provides standards that ordinary statutes have to comply with. these are the basic principles of constitutionalism, that the constitution is most supreme, that it upholds the rule of law, that it provides for the separation of powers and constitutes various institutions of the government in a way that limits arbitrariness of power. And it provides various standards and rules that ordinary statutes have to comply with. Ordinary statutes are those laws which are not the constitution. For example, it could be the land laws, the mortgage law, the banking law, the contract law. Constitutions as social declarations, they often attempt to varying degrees to reflect and shape society by expressing the common identity and aspirations of the people, or by proclaiming shared values and ideals. Other substantive provisions of the Constitution, particularly those defining socio-economic, as we already discussed this. The Constitution prescribes a country's decision-making constitutions identify the supreme power, distribute power in a way that leads to effective decision-making, and provide a framework for continuing political struggle. The political provisions show how state institutions, that is the parliament, executive courts, head of state, local authorities, and so on, are constituted, what powers they have, and how they relate to each other. There are two constitutional archetypes, procedural and the prescriptive. Differences between these two relate to the nature and purpose of the Constitution itself. A procedural constitution defines the legal and political structures of public institutions and sets out the legal limits of government power in order to protect democratic processes and fundamental human rights. A procedural constitution may be appropriate in cases where it is difficult to arrive at a common agreement over issues of values or community identity, but where it is possible to reach a more limited and pragmatic consensus on using democratic procedures to resolve these differences. So, in a way, it's more theoretical. The Canadian and Dutch constitution closely reflect this type of constitution. They proclaim no single vision of a good society, but rest only on the minimal commitment to live together to solve common problems through political institutions and to respect the right of those who differ or disagree. They make little or no explicit mention of nation building or of fundamental philosophical or ideological principles. They contain few substantive provisions, that is, provisions settling particular policy issues, except where such provisions reflect pragmatic attempts to settle practical problems of corporations in a pluralistic society, that is, where language rights and ownership of resources in Canada and education in the Netherlands. So here it's a less the scope of the constitution is not as wide. It's rather limited to the community, and there is no sense of nation building, or it's a limited approach. Whereas prescriptive Constitution emphasizes the foundational function of the Constitution as the basic charter of the state's identity. For example, the Magna Carta in the UK, it is the basic identity of the UK Constitution, which plays this basic charter of the state's identity, which plays a key role in representing the ultimate goals and shared values that underpin the state. This is what I was talking about, what is given in the preamble of constitution. Usually in prescriptive constitutions, this preamble is given, which in brief encapsulate the basic values, the basic structure of a constitution, where the goals of the society, of the nation is provided, and the goals that both the nation shall achieve and the individuals shall achieve are provided in this preamble. Provides a collective vision of what might be considered a good society based on the common values and aspirations of a homogeneous community, that is a similar community. In addition to describing how the government functions, the Constitution assumes or attempts to impose a broad consensus on common societal goals that public authorities must strive to achieve. So there are these common goals that all branches of government, all public authorities or institutions of the state should strive to achieve. This is reflected in the emphasis placed on the Constitution's social content and in the ideological shape of its legal and political content. A prescriptive constitution may be appropriate in cases where a society wishes to re-establish on a shared ethical basis that is both symbolically proclaimed by and practically embedded in its supreme law. South Africa, Constitution 1996 and Ecuador 2008 provide examples of prescriptive constitutions. These two archetypes of constitutions are not firm categorizations. It is not one or the other. It is not one or the other. It can coexist. These two archetypes can coexist, but sometimes it leans more towards prescriptive, and sometimes it leans more towards the other. What does a constitution typically contain? Divisions. Most constitutions are divided and subdivided into parts that may be variously known as titles, chapters, articles, sections, paragraphs, or clauses. So, to better understand it, Constitution is a huge text, right? So it is divided into different titles, and these titles are divided into different chapters. These chapters are divided into different articles, and these articles have subsections and paragraphs and clauses. But whereas arrangement is concerned, constitutions vary in the arrangement of their provisions. Although it's now usual for principles and rights provision to be placed in a separate section near the beginning of the text, for the main institutional provisions to be grouped in the middle of the text, and for independent institutions, miscellaneous provisions to be placed near the end of the text. So if you read the different constitutions, different 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 provisions are in different parts. For example, the part relating to fundamental rights, it's usually in the beginning. And the part relating to different branches of the government, it's in the middle. Sometimes and relating to citizenship and national identity and jurisdiction and territories in the beginning. However, it depends on different constitutions. They might keep these parts in different areas, either the end, middle, or beginning. However, there is no specific formula to draft a constitution.
Miss, can you give an example like when you say title, chapter,
Yeah.
article, section, how when we are saying how we can refer like when we
Oh,
say
okay, okay.
something in the constitution?
Okay, okay. I'll show you the modern constitution. Okay. I have to change the I'm sharing. See, it's divided into different chapters. See, chapter 1 relates to state sovereignty and citizens. Chapter 2, fundamental rights and freedoms. Chapter 3, people's majlis, and so on. Okay, these are chapters. This is the title. Chapter 1 is the chapter title is state sovereignty and citizens. Here, what is numbered? They are articles. Article 1 defines the constitution. Article 2, Republic of the Maldives. Article 3, territory of the Maldives. Article 4, power of the citizens, and so on. And here, for example, this is Article 60 in Chapter 2. That is the second chapter. Title of the chapter is Fundamental Rights and Freedoms. And under that chapter is Article 16. The title of Article 16 is Guarantee of Rights. Now, there are sub-clauses of this article. Sub-clause A, sub-clause B, sub-clause C.
So
Is your doubt? Yeah.
මම හරි දිවෙන් කියන්නේ ගානූනු අසාසීගේ ෆුරතම බාබුගේ يعني මෙවැනි හග්ගුතකෙක්ගේ ඒකත සෝල වන මාද්දාගේ හාද ශවයනි එහෙන් දෙත්තෝ මීතරි
Yeah, that is how you say it in the yes.
බාබු එහෙමිම බාබු දෙත්තෝ ෆුරතම මේ බුලන් ජෙහෙනි Ganun asasi refer
Uh,
kuraruga.
yeah, when you make reference, you have to say it according to that order.
Okay.
Chapter, then title, then article, and if you're referring specifically to a subclass or subarticle, then you mention that also.
Misare komiswara ka divehin ki aden je kane komeni mis kotu takuga wani gotu ki algon me mechi refer kuraruga divehin detto mige reference demis jeheni. එහෙම වි මානේ ඒ තිස්ත තංකොළ බොඩන් අනිකත කොල්ල එබති ඒ කන්නේ. Thank you.
Yeah. Like, is it clear now? Can I go back? Yeah, so those are the divisions. The layout of a typical constitution might resemble the following. It contains a preamble, which is the statement of the overarching motives and goals of the constitution making exercise, sometimes referring to important historical events, national identity or values. And then after the preamble is preliminaries, a declaration of sovereignty or of basic principles of government, the name and territory of the state, citizenship and franchise, state ideology, values or objectives. That these things are usually in chapter 1, chapter 2, chapter 3. Then fundamental rights provides a list of rights, including how they are applied, how they are enforced, the limits on fundamental rights, the suspension or restriction during a state of emergency, or situations in which these rights cannot apply, social and economic rights or policy directives, parliament or legislature, its structure, composition, terms of office, parliamentary privileges and procedures, and so on. Head of state, the method of selection, powers of the head of the state, term of office. Head of state is also it might come under the heading of executive or the president or the crown, depending on who exactly the head of state is in a country. Government in a parliamentary or semi-presidential system, a government formation, rules of the government, responsibility, judiciary, what exactly the court system is, judicial appointments, judicial independence, public prosecutors, subnational government if it is a federation, devolution of powers, federal or devolved powers, powers of the local government, provisions for referendums, institution of the fourth branch or integrity branch, other commissions, electoral commission, ombudsman or ombudsperson, auditors, auditor generals, security sector. It constitutes the security sector, the commander-in-chief of the army, any restrictions on military power, other miscellaneous provisions relating to flag or language or institutions or religious matters. And towards the end, it's the amendments made to the Constitution are provided along with other schedules or appendices. Size and length. Constitutions vary in length from a few thousand words, such as the constitutions of Iceland and Latvia, to more than 50,000 words, such as that of India. Newer constitutions tend to be longer than older ones, and federal constitutions longer than unitary ones. National constitution is National Constitution is in printed form may vary from the size of a small pamphlet to that of a fairly large book. Anyway, so I think we have to discuss written and unwritten constitution here. So usually the more modern constitutions currently are written constitutions. However, much older constitutions are unwritten. For example, the constitution of the UK is unwritten. But when we say that a constitution is unwritten, it does not mean that it's not written down anywhere. When we say a constitution is unwritten, we mean that a constitution is not codified. It's not all together in one. The constitution of the UK it consists of different pieces of text, different laws, which essentially form the constitution. It's in different places, but it is the constitution. For example, the Bill of Rights or the Scotland Devolution Act. It is the constitution, but it is in different places. In that sense, it is unwritten. It's not codified. But there are people who have attempted to compile these different laws which make the UK constitution and make it more understandable in the sense that other modern constitutions are, for example, the constitution of Maldives or the constitution of India or Ireland. So it is compiled in that particular in that order, so that it's easier to understand. You can take a break till